shoot.
Are you going to enter the transaction in the inspection period?
Hopefully, no. So hopefully you get me involved before there's a contract involved. But that is not.
Say I have the buyer.
If you have the buyer, I could, as soon as the violation is uncovered or the open permit or expired permit, sometimes we all use a seller's disclosure. We should. And so if you're listing a property, the seller says he don't know or he knows, but a lot of the times these sellers, they don't know if a contractor called for final inspection or closed out their permit. They just showed them they got a permit, started working, asked for final payment, and flew the coop. And unfortunately, all those times it's the property owner's responsibility. But I'm not a home inspector. We're used to home inspectors. I do some commercial property inspections in 40 years, but I'm usually brought in by the buyer or seller before, when they know there's a code violation and they want to list the house, or the buyer is in their inspection period. They somehow know that there's a code violation and they want it evaluated because for whatever reason, market conditions, they can't bring the seller to terms. But most of the time I'm working with sellers and the property owner, but sometimes I'm brought in by buyers as well. So when you find this out, to answer your question short, when you find this out, the best thing is to bring me in as early as possible. And again, even if I represented the buyer, maybe I might, want to go online. Maybe I might want to contact, the title company and say, hey, because there's a couple different parts of the lien search. Hey, can you help me with this? And, Mei Ling will do that. Can you help me with this? The owner was saying that there might be something, that they had a problem with the city. Call the title company and say, hey, when is the quickest we could find out about this information? And hopefully you can find out about it within the inspection period or as soon as possible, so it doesn't delay the closing. So that's how you can protect your buyers. And you can, and this is very important to them, as obviously rates are changing, things like that. And all our contract says is that the seller needs to cooperate with access, right? So it doesn't say who's to remedy these things. About 5 years ago, maybe 4 years ago, the Florida Realtors lobbied in House Bill 447, which basically the state legislature enacted a bill to tell the municipalities to close out permits after 6 years old. But unfortunately, it gives the building official and the jurisdiction the right to choose what they want to do or not. And a lot of times the building departments, they want to collect their fees. They want someone to be responsible for the work, like a contractor, and they want to come out to inspect it. And they could determine, again, most of these things, they can be life safety issues. Electrical that's unpermitted, open pool permits, all these things. I mean, these are life safety issues. Have I seen them administratively close permits? Yes. For example, there's an open roof permit after Hurricane Andrew. Miami-Dade County was stacked to the T on Carl Way. I don't know if that's where they were located. I was in kindergarten then, but I think they were there. And so they're stacked to the T, and then the permits were left open, or unpermitted work went on, or they didn't call for the 4 inspections before they closed up the roof. And so later on in 2005, which is 15 years later, they pulled a building permit for a roof and closed that permit. So that's like an administrative closeout. If I can help you guys with that and find out the information for that, I would love to do that. I'm not looking to sell your client a new roof on their property. I'm a roofing contractor. I'm a licensed roofing contractor, but I'm not looking to sell you guys a new roof or put money into the property. And the problem is, when most realtors or property owners are calling contractors, they're not true owner's reps, and they're looking to do work, more work, and more work. It's similar to the 40-year recertification. If any of you are on a condo board, like I am, you hire an engineer to look for problems, and then they call in their cousin who's the electrician, and their brother who's the roofer to supplement those problems. But it needs to be basically, an owner's rep is an owner's rep, an engineer is an engineer. They shouldn't be associated with other parties. So I'm not developing my own scope of work. So there's some checks and balances there, and that's, as much as I find the cities frustrating, they're there for consumer protection. They're there to make sure that, and in North Miami, Opa-locka, El Portal, where they did the reoccupancy inspection in Hialeah Gardens, which that we hate that in this room, because they come to properties and they find problems. They're looking to find problems before a property closes, before it transfers ownerships. Because they have a lot of properties for 40 or 50 years that had sheds with electric, that were built out all the way to the property lines. So the cities are looking to phase out problems. But you're coming to sellers, an old lady who needs to sell the house, an elderly person, should I say, and she doesn't have the money to fix them. So that becomes the issue. And we work on, for those, they offer stipulated agreements and different things. Sometimes you have to fix them. But, you know, sometimes, very rarely, I work on things and I get paid on the HUD. Sometimes we meet with the city attorney or the building official, like in North Miami, and we sign a stipulated agreement, which says they have a year to take care of it after closing, or they lose because they have $5,000 being held by the city, you know.